Good morning. Thank you everyone for being patient. It's 9:03 and we want to be cognizant of everyone's time. My name is Sarah Washington and I am the president of the UB Law Alumni Association's Gold Group. Thank you for attending today's CLE presentation entitled Trial Presentation Technology, Navigating Trials, Even During a Pandemic. This is one in a series of many virtual programs the Law Alumni Association and Gold Group are hosting as a service for our alumni and law students. If you are interested in attending other upcoming webinars and CLEs, you can register directly on UB Law's website, law.buffalo.edu/alumni events. You can also listen to past CLEs and other webinar recordings at no charge on our new alumni education webpage, also located on the law school's website. To get discounts and select free 1-hour CLEs, please consider either an annual or lifetime membership to the UB Law Alumni Association. You can join on our website, law.buffalo.edu/alumni/membership. I'll post that link in the chat. Finally, I'd like to thank the Gold Group sponsors who have helped to underwrite the costs associated with our events this year. Chicago Title, Council Press, Equitable Advisors, one of our presenters today, Jack W. Hunt and Associates, as well as Precision Resolution LLC, Paramount Settlement Planning LLC. Now, a few brief administrative points. All of today's attendees will be muted during the course of the presentation. If you have a question at any time, please use the chat room and we will address questions at the end. At some point during this morning's CLE, the course code will be announced. I will also place it in the chat. Please be sure to catch it, as you will need to put it, as we all know, on the attorney verification form so that you can get credit for attending today's CLE. Please also return the program evaluation form on that page. I'm now going to turn it over to one of today's organizers, Ari Goldberg.
Thanks, Sarah. Good morning, everyone. As Sarah mentioned, my name is Ari Goldberg, graduate of the Law School and Educational Co-Chair Committee of the Gold Group. Great pleasure to introduce Colin Campbell, class of 91, and Tim Hunt from Jack W. Hunt Associates, who will be our presenters today. A bit about Colin. So he graduated UB Law in 91 and he began his career in insurance defense. And then he switched sides over to plaintiffs in personal injury and medical malpractice cases. He resides in Eden, where he serves as town prosecutor, town justice, member of the school board, and president of the Boys and Girls Club. Some of Colin's successful case results is a verdict in a medical malpractice case for over $4 million for a man who sustained neck and back injuries during a kidney surgery at a local hospital. Colin has also litigated in admiralty law, one case on behalf of the family of a crew member who was on a lake freighter and then fell into the hold of the ship, ultimately dying of his injuries. After extensive discovery in multiple states, the case settled for over $5 million in 2017. And in recent years, Colin has also began working as a trial consultant for other plaintiffs' injury firms. Most recently, this past May, Colin obtained a jury verdict of $1.5 million before Judge Marshall in a medical malpractice case that was conducted with COVID restrictions in place, which makes him uniquely situated to be one of the presenters today. And then as to Tim Hunt, Tim is a 1975 graduate of SUNY Buff State. He joined his father's firm, Jack W. Hunt Associates, in 1979 with the goal of bringing the use of video recording to the Western New York bar. And as the technology moved from reel to tape to video cassette and now electronic files, Tim has continuously stayed in the forefront to ensure that Jack W. Hunt offers the latest electronic method of capturing testimony. Jack W. Hunt has been providing trial presentation support of electronic evidence to the Western New York bar since 1979, and they've evolved from tube TV sets to flat screens and now even iPads. Tim has been integral in leading the charge in bringing the latest in trial presentation support technology and electronic service to Western New York, along with the rest of Jack W. Hunt, who has a very strong showing on the CLE. So I thank all of them for attending, and we wouldn't be here without their continuous support.
Thank you, Ari, and good morning, everyone. The way Tim and I thought we would present this to you this morning is going to be a little bit like a ping pong match. I'm going to start and just give a brief overview of the facts of the case, and then talk about what challenges were presented to us by the COVID protocols in place in terms of trying to present the case to the jury. And then it's going to go over to Tim, and he's going to explain to you how the courtroom technology they provided was used to specifically address some of those issues and problems. And then we're going to it's going to go back to me, and we're going to actually go through some of the exhibits that were shown to jurors on their individual laptops in that case. And then back to Kevin again, and he's going to tell you a little bit more, or Tim, I'm sorry, we'll tell you a little bit more about the specific equipment used and how it was set up. And then if everything goes according to plan, we should have some time left for questions. I also want to mention and thank my paralegal, Heidi Luongo, and Mary Grace Sherry from Jack Hunt, who are assisting with the technology today. So in this medical malpractice case, my client was a 46-year-old woman who had been recommended to have an open hysterectomy to remove fibroid tumors, which were causing her to have painful menstruation. Her OBGYN, who was the defendant in the case, told her that she was a good candidate for the surgery. She had no other health issues. And she told my client it would be basically a straightforward routine procedure, and she should be in and out of the hospital in about 3 days. And following the surgery, the doctor's operative report that she dictated indicated that basically everything went fine, and there were no complications in the surgery. However, following the surgery and continuing after discharge from the hospital, my client had increasing abdominal pain. She had no appetite. She was not eating much. She had some other additional symptoms of bowel injury as well. And she was reporting those to the defendant and the defendant's office, but they were not really taking those reports seriously. And that went on for a week and a half. And it was actually 13 days after the surgery, I believe, before there was any action. And at that point, my client was very, very ill. She was told at that point to go to the emergency room, where they did a CAT scan, which turned up or showed that there were some abdominal abscesses or pockets that would be consistent with a perforated bowel and leakage from the perforation. And at that point, they sent her right to the OR for emergency surgery. And in that surgery, that surgeon found a very small perforation, just a tiny hole, 0.3 centimeters it was. The cecum is part of the large intestine that links up to the small intestine. But he found that hole from which bowel contents had been slowly leaking into her abdominal cavity and making her, over that period of time, infected and septic. Okay. And that surgeon then had to do a resection of her bowel, which cut out the damaged portion and gave her a temporary ileostomy with a bag. And we had 3 primary allegations against that defendant doctor. First, we said that causing the injury to the bowel by misusing equipment or instruments that she was required to be in control of, that was negligence. The second thing, that not realizing that there was an injury and doing something about it before she closed up the patient. that also constituted negligence. And the final allegation was that following the surgery and following my client's discharge from the hospital, they didn't recognize or respond to the symptoms of bowel perforation. Okay. So with respect to the first claim that we made, what caused the injury and how that happened, the defendant doctor said, well, she said she had no memory of the procedure or the details of the procedure. She said she had no idea how that could have happened. Her testimony, though, was that she knew one thing for sure. She knew that she didn't do anything wrong. She knew that it wasn't her fault. Okay, that was her testimony. Now, our expert in the case, also an OBGYN, he had a theory that this injury probably happened because the defendant had trapped part of the intestine in the arm of a metal retractor. This equipment is called a Balfour retractor. And it's placed in the patient's body to hold things in place and basically give the surgeon an open, unfettered view of the operative field. Okay, and he thought that that intestine was trapped or pinched in that position for maybe an hour or so during the course of the surgery. And that would be long enough. That pressure and that pinching, cutting off the oxygen, would be damaging the tissue of the intestine, would weaken it, okay, and then make it susceptible to a blowout type of perforation. And that wouldn't necessarily happen immediately, but within days of the surgery. And even a tiny perforation like what we had in this case, everyone agrees that can be extremely serious and life-threatening. So that's kind of the overview. Now, obviously, we have the burden of proof, okay? And what that means is we have to convince 6 random people pulled off the street that this somewhat technical theory is probably what happened, okay? And in order to do that, I think you need to teach them and show them how it happened. Okay, and doing that is a challenge under any circumstances. And one way I have found that I think is pretty effective is to have a medical artist work with your expert physician to create anatomically correct drawings that show the steps of the surgery, the relevant anatomy, the relevant tools and equipment. And then the expert can kind of go through and sequence and teach the jury and show them what probably happened here. And in normal times, the jurors would all be sitting together in the box and the expert would come down with a pointer. The drawings would be blown up on boards and the expert would use a pointer and go through them. And he or she, the expert, would really be the center of attention, the star of the show. And if they were a good witness, you would want that. But these are not normal times. Okay? We have these COVID precautions in place. And with this trial in May, the jurors were not all in the box together. They had to be 6 feet apart. Okay, so they were in kind of a semicircle around the side and back of the room. Okay, very spread out. I think we have a diagram that might be the next. There we go. So you can see how they start in the jury box and then they went all the way around the courtroom into the gallery, extremely spread out. So obviously you're not going to be able to have an expert down in front of them presenting anything. It's just not going to work. Now, presently, I believe the 6-foot rule has changed, and they are now allowed to sit closer. They just can't be right next to each other. I think there's a requirement that there be an empty seat in between. And I've had cases in the Falls and in Mayville since then that were done that way. But we can't really predict, obviously, how it's going to be next month or next year. So that was an issue. Second thing was that everyone in the courtroom had to wear a mask. And there is an option available whereby witnesses, if you so choose, they can wear one of those plastic shield things. Okay. I looked at that, I thought about it, and I didn't want that for a couple of reasons. First of all, they look dorky. Also, in this courtroom at least, and I think it would hold true in most courtrooms, when the shield was on, the overhead lights created a glare and made it so at times you couldn't even see the witness's face because of the glare. I also thought about it, and I didn't focus group this or anything. I just had a feeling about it. It occurred to me that since the jurors were all wearing masks, maybe we should all just stick with masks too, and not make ourselves different or special. Kind of, we're all in this together kind of thing. And but the problem with masks is, as you know, they muffle your voice. So here's a tip. A friend told me about this. There are masks that don't muffle as much. They are made for sports activities, I think. And I got some of those, and they work pretty well, and they look just like any other mask. But you can speak clearly through them. If you're interested in those, a couple of judges have asked me about them, and I've given this website to judges. The website is sportfitting.com, and you can order those masks there. But even with a good mask that's not muffling, you're covering half the face. So I think that it impacts the appearance of the witness, it impacts their ability to communicate, and with respect to those things, it could even impact their credibility. So where in normal times, you might want the jury to be focused and staring at the expert, maybe now you don't want that. Maybe it would be better to have the jury focus on something else, like exhibits. And while their focus is on the exhibits, just let the expert narrate or kind of tell the story in the background as they're looking at the exhibits. And if the expert were able to actually manipulate those exhibits from the witness box, pointing out things, enlarging things, highlighting things, that would be all the better. Now, as we see on the slide here, there was a large screen available in the courtroom, and there was also an Elmo, an overhead projector, which you could put documents on, and it would project up onto the screen. And we did use that from time to time for records and such. But it was pretty far away from the jurors. If we look at that courtroom diagram again, the courtroom yeah, there it is. You can see the screen was in that upper right-hand corner. It's pretty far away from some of the jurors, and not everybody had a good view. And it just, for what we wanted to present, the detailed anatomical drawings and our theory of the case, it just wouldn't have worked as well. It just wouldn't have shown the necessary details and so forth. And one final thought about this. let's face it, if there is a way to present important information to jurors in a way that they are all accustomed to receiving it. By that, I mean in their normal lives outside of the courtroom. Maybe that would be a really good, effective way to do it. Okay? If you think about 20-year-old jurors, they're not going to find listening to a talking head for an hour or two very enticing or interesting, I don't think. They are used to receiving information through the computer screen, through their phones, through their iPads. So maybe that would be the best way to present things to them. Now, Tim, I'm going to turn it over to you to explain how we address all this.
Thank you very much, Colin.
And Tim, before you start, if I could just jump in with the course code. Today's course code is trials, and I'll put that in the chat. Back to you, Tim.
Thank you very much. Colin, thank you very much for the nice introduction of how the case developed. As Colin indicated, he came to us. We had done a previous trial in the same courtroom, so we had some familiarity with the layout. And obviously the issues that Colin has talked about, the jurors being distributed throughout the courtroom with 6 foot between each juror. And Mary Grace, if you'd bring that, in actuality, some of the jurors were seated all the way over in the far box, far corner of the gallery. So as Colin indicated, there's no way that a single picture could easily be displayed unless you were doing a Price is Right type of presentation where you're walking around the courtroom with it. So, you know, the previous trial also had some of the same issues. And so what we did was we ended up leveraging the ability of Zoom to have a meeting with multiple participants. And then what we selected at the moment, we're using iPads for the jurors. The judge ends up getting an iPad Pro for a larger picture. We also hand an iPad to the witness, as well as opposing counsel. So you've got about 9, 12, maybe 13 iPads, all depending upon how many opposing counsel need to have one. They're all handed out, and we have to go through and set them up properly. So that's a little bit of an effort, because you've got to make sure that the iPads for the jurors aren't showing the jurors' faces back to the participants. So all of the jurors' iPads, in other words, have the cameras turned off, so they're just a viewing device, like a personal TV. Additionally, you don't want to have multiple microphones and multiple speakers in the courtroom. That would create a significant amount of feedback. So that has to be managed. And the other thing that you've got to be concerned about is the fact that even though iPads have a fairly good battery life, you've got to make sure you have additional auxiliary power. So that's another thing that we bring in. So we set them all up. There is a central laptop that sort of controls the meeting, and the witness gets a laptop. And so now the witness can manipulate the laptop with the diagnostic studies. And the witness is, from my view, the best person to do that, because they normally have the best familiarity with the programs that are being used. So in this instance, Colin will later, I believe, talk about some diagnostic studies. Obviously, if the diagnostic studies are from a hospital, the witness has knowledge of how to manipulate that program. If they're PDF documents, the witness again can reference that PDF document, and he can blow the document up to the size that he wants. And the reason why he ends up with an iPad as well is so that he can tell what the jury is seeing. Because what's on his laptop is probably going to be larger than what the jury will see, only because it's a different size factor. So we came in, we set it up, and then we turned it back to Colin so that Colin can actually try the trial and get to his successful verdict.
Okay, now we'll go to some of the exhibits that were loaded onto the laptop that our expert had with him in the witness box. Okay. And if anybody's wondering how there's any evidence geeks out there that are wondering how did we preserve the record, the appellate record for with respect to this information. What we did is for each of these exhibits that we loaded, we printed out 8x11 size copies, and those were marked and those were admitted into evidence. So that preserved the record. But this first exhibit, so I had mentioned the anatomical drawings. This is an example of one of those done by a medical artist. It shows the anatomy, it shows the equipment that the expert wanted to talk about. And all he did was he went through these drawings and explained how the steps of the surgery, how it was done. And then he showed and was able to zoom in on certain aspects, like I'd mentioned the retractor, and the arm of the retractor is over to the left there. And you can see the arrow moving. He was able to do that as well and point out different features as he talked about them. That arm, that metallic arm, you can see is in very close proximity to the intestine. So he was able to explain how the intestine could, if the doctor's not careful, the intestine can very easily become entrapped by that arm and be trapped in that position for the entire length of the surgery. Okay, so if we go down then to the next board or the next diagram, he's just getting further into the surgery. Okay, but again, he would go back to and show that arm and show its proximity to the intestine and explain that it's still trapped at that point. During these steps of the surgery, it is still trapped and oxygen is being cut off, and that's damaging tissue. And then one more step down, the next diagram is, again, he's working through the surgery and again, describing the entrapment of the intestine. So he was able to teach, as I said, teach and show the jury what probably happened to cause the plaintiff's injury. And I think that was very powerful. And then we had other exhibits. If we go down to the next exhibit. So some of the records, some of the reports were also used in this manner. This is the operative report for the defendant doctor's hysterectomy surgery, where she says that there are no complications. It was basically routine. Nothing was wrong with it, no complications. The reason we wanted to have him highlight and use this report was because to answer or rebut his theory, they spent a long, long time during her testimony having her testify that she went, with respect to this retractor, she went through, she had no memory exactly of the surgery, but her testimony was she knows that she went through all these steps to make sure that she safely placed the retractor and the padding around it. And it takes a long time, and They just spent a very long time on that. So to respond to that, we just wanted to show in this report, which is supposed to contain her description of everything she did during the surgery. We wanted to see what was that, if what she had described doing all those careful steps was anywhere in the operative report. In other words, what did the report say about the Balfour retractor and in the steps that she took to place it in the pads, the safety pads? So we put the report up, and in this entire report, I think it's 3 pages, there it is. There's one line: a Balfour retractor was placed and the bowel was packed up with 2 lap packs. Well, I think that hurt their presentation when that was pointed out. And then if we go to the next exhibit, this is the pathology report that was done following the repair surgery, where the surgeon did a resection and took out the damaged portion of the intestine. And we thought this was important to highlight there's a description of the damaged portion of intestine that was removed, and in particular, and it also has a description of the perforation. So if you go down to 10 lines down or so, the wall at the cecum is thinned, and that the thinning was something he wanted to highlight and talk about. It was very important because it was consistent with his theory. The thinning was an indication that the process of damage, the oxygen being cut off and the pinching and so forth, had actually occurred. There it was, right in the pathology report, something that supports and is consistent with his theory of how this injury occurred. So that was highlighted on that exhibit. And then if we went on to I think there's one more exhibit. Okay, this is a anatomical drawing representing the repair surgery. Okay, and it allowed the doctor to explain what had to be done to repair the injury. And you can see he went down to the cecum and showed the area of the injury. If you can enlarge that or zoom in on that. Yeah. On the right hand side, you see the cecum is labeled. That's where the perforation was. He also talked about, the yellow stuff is the bowel contents that had leaked out, and it's inflamed. And so he was able to show all that to the jury and discuss it with them. All of which, again, was consistent with his theory and supported his theory. So that's all I have on the exhibits. My takeaway from my experience in that case with this is that I think it's an extremely effective way to present information to a jury. And I think it would work well with virtually any important evidence that you would want the jury to really focus on. Not only the types of things that we use here, but I'm thinking about animations, diagnostic films, photos, really anything. In fact, Tim mentioned diagnostic imaging. We had actually made arrangements to use this technology in another case I had in the Falls. And that case was an auto case. And the big fight was over the before and after conditions of the plaintiff's neck and back. And we were prepared to use the laptops to show a comparison of the before and after MRI films with an expert discussing those. And I think that would have been very effective. But the case settled after jury selection. So we didn't get a chance to try that out. But I will be definitely keeping this in mind in all my future cases. And I think that will continue even when we get back to normal, whenever that may be. I would still want to use this technology because I think it's so effective. That's all I have. Tim, you wanted to talk more about the specifics of the technology?
I could certainly go into some more tech issues. The main thing is that what we're doing is not really proprietary, so anyone can do it. Obviously, it requires an investment in equipment. It also requires an investment in training, like anything. And then finally, when you're doing something like this, you need to be prepared for failure. Because, sorry about that. I have this tie that all of a sudden wants to do jingle bells. So just be prepared for failure, just like my tie, and have backups so that you can, reset and continue on. We obviously, there's a cost to the preparation and to this technology. Happy to send you and to provide to you a spreadsheet that you can populate yourself to get an idea as to what the cost may be. You can certainly substitute some of the items, and we'd be happy to talk to you about that. But the main thing is that it does provide you another way of presenting evidence that's in the courtroom from a live witness. And then you have to think that because of COVID, because of travel restrictions, people still not wanting to fly, if you've got experts out of the area, you can still bring them in through the same Zoom meeting. Some additional technology needs to be provided, but they also can, as Colin indicated, can be used to show demonstrative exhibits. I think that's probably enough. We're at 9:40. How are we doing from a timeline standpoint? Is it time for questions?
We have about 20 minutes. Right now, there haven't been any questions in the chat. So if anyone has any, feel free to type them in the chat or say it out loud.
We only need 50 minutes for the credits, so if we're running a little short, that's fine.
Okay, well, so let me go on with some of the technical things. Again, I mentioned previously that we provide, or what you should have, is auxiliary backup. So every iPad, even though they may have a 7-hour battery life, we provide a battery that provides an additional 10 hours. Of course, what that means is at the end of the day, you've got to charge all of these items so that the next day when you come in, you don't end up with a dead item. You can use the court's Wi-Fi system, but you're running a fair amount of bandwidth with this trial. So we end up using hotspots, and we end up dividing no more than 10 electronic devices that need to get to the internet to each hotspot. So therefore, what we come over to the court with is something that can handle up to 20 items. And that would include not only the iPads, but also your laptops. We've already talked about how to set the iPads for all of the participants up so they're not replicating sound. When you have a live witness, you obviously can use the microphone system in the courtroom. That's preferred. If you go to a external witness, the additional equipment that you need to bring in is a microphone, a unified microphone, so that you only have one microphone speaking from the courtroom. And we end up using a Yeti podcaster microphone. And then you also need to have a speaker system, because you really don't want to use the courtroom's speaker system. So we bring over a Bose speaker. And the reason why you don't want to use the courtroom speaker system is because there will be a delay between what's coming out of the system equipment, the Zoom system equipment, and what is going to come in through the courtroom system, and it gets very troublesome. So then you've got those two additional items. The big thing with an external witness is obviously try as best you can to make sure that they are familiar with the technology of Zoom. And as you all know, witnesses vary. They can be great, and then some of them can be less than desirable. And I would strongly suggest that as you talk to a witness that you want to bring in externally, that you have them run through a Zoom meeting and make sure that they can control at their end the items you want them to display to the jury, and that they understand that during a Zoom meeting, they need to be cognizant of speaking as you do, one at a time, because when you're in live, you can have two people talking and the jury can probably hear both and their minds will switch back and forth. But with Zoom, a problem is that you've got a single audio stream and the microphones are designed to cut off when someone from the far end is speaking. So you end up with audio dropouts, and therefore the comprehension is harder. The nice thing that, as I'm going back to Colin, the issue is, the nice item about this is that you can have the document at the end, no farther away than the end of the witness's arm. So visually, it's much better. And if you're like me, I wear glasses for close-up. If I use these glasses to see if a document that is 6 foot or better away, and in this instance, most documents are probably 12 foot, just because of the jury box. If I go to my regular eyes, that's worse. And if I go to my distance glasses, it doesn't give me the detail. And I can't blow that document up to show the detail. So all of this is new for you as the practitioner of bringing the evidence forward to the jury. Colin did a great job, obviously, and I was glad that he engaged our firm to help him with that.
Thank
Tim,
you.
one of the questions in the. Go ahead,
Oh, sorry.
Tim.
Go ahead, Ari.
Okay.
What
One of
I
the
said
questions.
about talking twice.
One of the questions in the chat was about the jury's reception to the technology, and then I would just want to expand on that. Is what was the judge's reception? Because would he or she be the one that permits this technology going forward?
Well, it was Judge Marshall, and I knew that he had already allowed it in a case just prior to ours. So he had no problem with it. And I can't say that we did any post-verdict interviews of any of the jurors, but I like to think the result speaks for how effective it was. I don't typically do post-verdict interviews of jurors. I did earlier in my career, and I kind of found it to be a little aggravating and frustrating, and it might be a weakness of mine, but since then I've hesitated to do it, and I didn't find it to be productive in those times. Maybe I should go back and try it again. I do, on my list of things to do, I do want to certainly do more things with focus groups and presenting ideas and things to them. And it would be interesting to take this technology and present some exhibits on iPads and things like that to a focus group and just get their thoughts and ideas about it. And maybe show them different ways of presenting the same evidence and see what their response was in terms of how effective each different way was. I've thought about that.
I can tell you that when we were working with Justice Marshall on the trial previous to Collins, he obviously wanted to get the trial moving. So he was more than receptive to anything that would allow, and we had 2 witnesses in that trial that couldn't travel because we were still in the no travel timeframe. And the witnesses didn't want to travel, frankly. So he was very impressed with being able to bring it in. All the jurors could see. I think the jurors found it useful. Again, we don't do questions after the fact. We can't, but that's just my feeling. I know that the attorneys in the first trial, the attorney who was not successful, he still thought that the ability to bring the information to the jurors' arms was very important. The attorney who was successful thought that it was excellent.
Great, thank you, Tim and Colin. Are there any last minute questions from any attendees? Okay, hearing none, our time has now expired. I'd once again like to thank our speakers, Colin and Tim, for their time and insight. You will be receiving more information about future CLEs with our next one to be scheduled in February, which will be our annual ethics CLE. Please check our website for details regarding this upcoming CLE. Everyone, please be sure to send in your attorney verification form. I put the link to how to access that form in the chat. Again, the course code for today's CLE was trials. And be sure to submit that directly to Pat Warrington so that you can receive your CLE certificate. On behalf of the Gold Group and the UB Law Alumni Association, I thank you for attending this morning's CLE. Have a great day, everyone, and happy holidays. Bye-bye.